Parliament passed the Citizenship Amendment Bill 2019, which received the President's assent to become an act. The Citizenship Amendment Act 2019 seeks to amend the Citizenship Act 1955. The Citizenship Act 1955 provides various ways in which citizenship may be acquired. It provides for citizenship by birth, descent, registration, naturalization, and by incorporation of territory into India. In addition, it regulates the registration of overseas citizens of India, card holders, OCIs, and their rights. An OCI is entitled to some benefits such as multiple entry, multi-purpose lifelong visa to visit India. An illegal migrant is prohibited from acquiring Indian citizenship. An illegal immigrant is a foreigner who either enters India illegally, that is, without valid travel documents like a visa and passport, or enters India legally but stay beyond the time period permitted in the travel document. An illegal migrant can be prosecuted in India and deported or imprisoned. In September 2015 and July 2016, the government exempted certain groups of illegal migrants from being imprisoned or deported. These are illegal migrants who came into India from Afghanistan, Bangladesh, or Pakistan on or before December 31st, 2014 and belong to the Hindu, Sikh, Buddhist, Jain, Parsi, or Christian religious communities. Key provisions on the Amendment Act. The bill amends the Act to provide that the Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians from Afghanistan, Bangladesh, and Pakistan who entered India on or before December 31st, 2014 will not be treated as illegal migrants. In order to get this benefit, they must have also been exempted from the Foreigners Act 1946 and the Passport Act 1920 by the central government. The 1920 Act mandates foreigners to carry passport, while the 1946 Act regulates the entry and departure of foreigners in India. Citizenship by registration or naturalization. The Act allows a person to apply for citizenship by registration or naturalization if the person meets certain qualifications. For instance, if a person resides in India for a year and one of his parents is former Indian citizen, he may apply for citizenship by registration. To obtain citizenship by naturalization, one of the qualifications is that the person must have resided in India or have been in the service of the central government for at least 11 years before applying for citizenship. The bill creates an exception for Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians from Afghanistan, Bangladesh, and Pakistan with regard to this qualification. For this group of persons, the 11 years requirement will be reduced to 5 years. On acquiring citizenship, first, such person will be deemed to citizens of India from the date of their entry into India, and second, all legal proceedings against them in respect of their illegal migration or citizenship will be applicability of the amended Act. These provisions on citizenship for illegal migrants will not apply to the tribal areas of Assam, Meghalaya, Mizoram, and Tripura included in the 6th schedule to the Constitution. These tribal areas include Karbi Anglong in Assam, Garo Hills in Meghalaya, Chakham district in Mizoram, and Tripura tribal areas district. Further, it will not apply to the inner line areas notified under the Bengal Eastern Frontier Regulation 1873. In these areas, visits by Indians are regulated through the inner line permits. Currently, this permit system is applicable to Arunachal Pradesh, Mizoram, and Nagaland. Manipur has also been brought under the inner line permit (ILP) regime through a gazette notification on the same day the bill was passed in this parliament. Cancellation of registration of OCIs. The Act provides that the central government may cancel the registration of OCIs on certain grounds. These include if the OCI has registered through fraud or if within 5 years of registration, the OCI has been sentenced to imprisonment for 2 years or more. or if it becomes necessary in the interest of sovereignty and security of India. The bill adds one more ground for cancelling the registration, that is, if the OCI has violated the provisions of the Act or if any other law as notified by the central government. The orders for cancellation of OCI should not be passed till the OCI card holder is given an opportunity to be heard. Concerns against the Amendment Act. Issue in the Northeast. It contradicts the Assam Accord of 1985, which states that illegal migrant, irrespective of religion, heading in from Bangladesh after March 25, 1971 would be deported. Critics further argue that the extensive exercise of updating the National Register of Citizen (NRC) will become null and void due to this Amendment Act. There are estimated 20 million illegal Bangladeshi migrants in Assam, and they have inalarmingly alerted the demography of the state, beside putting a severe strain on the state's resources and economy. Critics argue that it will violate of Article 14 of the Constitution, which guarantees the right to equality and the applicable to both the citizens and foreigners, and the principle of secularism enshrined in the preamble of Constitution. India has several other refugees that include Tamil from Sri Lanka and Hindu Rohingya from Myanmar. They are not covered under the Act. It will be difficult for the government to differentiate between illegal migrant and those persecuted. The bill throws the light on the religious oppression that has happened and is happening in these countries, and thus may worsen or bilateral ties with them. It provides wide discretion to the government to cancel OCI registration for both major offences like murder as well as major offences like parking in a no parking zone or jumping a red light. Government system. The government has clarified that Pakistan, Afghanistan and Bangladesh are Islamic republic where Muslims are in majority, hence they cannot be treated as persecuted minorities. According to the government, the bill aims at guaranteeing their rather than taking away someone's citizenship. It has assured that the government will examine the application for any other community on a case-to-case basis. This bill will come as big boon to all those people who have been the victims of partition and subsequent conversion of three countries into theocratic Islamic republic. Government has cited that the partition of India on religious line and subsequent failure of the Nehru-Liaquat Pact of 1950 in protecting the rights and dignity of the minorities in Pakistan and Bangladesh as the reason for bringing this bill. After independence, not once but twice, India considered that the minorities in its neighborhood are its responsibility. First, immediately after partition, and again during the Indira-Mujib Pact in 1972, when India had agreed to absorb over 1.2 million refugees. It is a historical fact that on both occasions it was only the Hindus, Sikhs, Buddhists and Christians who had come over to India's side. Regarding question of not including minorities from Sri Lanka, Myanmar, etc., the government clarified that the process of awarding citizenship to refugees has been undertaken by different governments in the past on case-to-case basis from time to time, on reasonable qualification to Article 14. This time, the case of refugee fleeing religious persecution from these three countries has been considered through this bill. In January 2019, government had notified the High-Level Committee for Implementation of Clause 6 of Assam Accord and argued to the committee to submit its report to the earliest to the central government for effective steps to be taken to fulfill the provisions of the accord. The government thus has assured the people of Assam that their linguistic, cultural and social identity would be preserved. Conclusion. The ONCE is now being the guardian of the Constitution to interpret the provision of the Act and test its constitutionality, whether the classification done in the Act is reasonable or not if tested against Article 14. India has a civilization duty to protect those who are persecuted in its neighborhood, but the method must be in accordance with the spirit of the Constitution. Further, the people of Northeast should be engaged more constructively to convince them that the linguistic, cultural and social identity of the people of the region would be preserved. Thank you. Jai Hind, Jai Bharat.